10th Circuit upholds disarming nonviolent felons, plus a Trump-appointed judge allows Hawaii to ban guns for adults under 21. All this and more on the news update.
No, the devil's got no hold on me.
All right, ladies and gentlemen, welcome back to the news update. I'm contributing writer Jake Fogleman, joined as always by Reload founder Steve Mitowski. TheReload.com, of course, is where you can head on over today to sign up for our free weekly newsletter to keep you up to date on all things happening in the world of gun politics and policy. This week's episode is also brought to you in part by The Dispatch, but more on that at the end of the show. To kick us off this week, it's very federal court heavy episode this week. There are a lot of several big rulings this week. First one comes to us from the 10th Circuit Court of Appeals, where a three-judge panel has just issued a new ruling in a case that it previously decided. But it was one of that original crop of cases that the Supreme Court actually sent back to the lower courts after its Rahimi decision, mostly dealing with, the felon in possession ban and a few other prohibiting offenses that the DOJ wanted the court to take up right away because it said that Rahimi and these other cases gave them no clarity. And what do you know? The 10th Circuit decided this case the same exact way they did the first time they had it and said Rahimi didn't change a thing. So they upheld, in this case, the felon in possession ban against a nonviolent felon.
Yeah, it's very surprising that
Rahimi, we're all shocked.
Again, had no impact on any of these cases that the court GVR'd. I mean, I think this was what we assumed would happen when the court decided to go that path, right? Because Rahimi, the pretty narrow holding in that case, didn't actually seem to impact any of these other cases. None of these cases were about somebody in a similar situation with a domestic violence restraining order, because most of them were about permanent disarmament over felony convictions or something like that, not just a restraining order and temporary disarmament, which is what the court zeroed in on its actual holding. They really focused on the fact that the Rahimi's case, he was only temporarily disarmed, and after a finding of dangerousness by the court. They obviously, there's something you could take away from the path that they took to get to that conclusion, which seemingly narrowed Bruen a bit, at least on the sort of straitjacket end of the spectrum between blank check and straitjacket, as the court had outlined in Bruen. You're not supposed to use the historical analogs as straitjackets or blank checks for modern gun laws. But that's not, honestly, that's basically what they said in Bruen. Right?
Right.
So they didn't change much of what they were saying. They just, and the holding itself was super narrow. So it wasn't, I don't think we were expecting them to really see a big difference in these lower courts, because the lower courts they were all saying all along that they were doing it the right way. It didn't, outside of the one court, the Fifth Circuit's panel that decided Rahimi, they weren't really rebuking any of these other courts. So, we'll have to see what the court actually does now that these have gone back through and come out the same way and also with people coming down on different sides of the issue as well. There's still a circuit split over age restrictions. That's probably the next story we're going to get to here. So, big kind of a swing and miss here. I mean, maybe just a delaying tactic from the court that feels like they don't want to immediately take up new Second Amendment cases, right? They haven't done any Second Amendment cases. They haven't taken any so far this cycle. And I don't know. I guess they want to let things percolate a little bit more in the lower courts before they do dive back in to give further clarity on the bounds of the Second Amendment. That at least seems to be the case with how they've acted toward these Second Amendment cases of late, including obviously Snope, the one that I think most gun rights advocates are most focused on, the assault weapons ban case out of Maryland. So, that one's still hanging around at the court, no decision on what they're going to do with it.
Yeah.
But yeah, not surprised. Not surprised to see this happen again.
Yeah.
Right.
And I think this one's interesting in particular because it's sort of the mirror image of the Range case. We talked about circuit splits on this question, where Range is a very sympathetic defendant. And the panel in that case said that, well, he can have his gun rights back. It's unconstitutional. The felon ban is unconstitutional as applied to him. And this case deals with a woman who 17 years ago was convicted for writing a fraudulent check at a grocery store for under $500 while she was homeless. So she was trying to buy groceries while she's homeless. And she has since cleaned up her life, and she's now a single mother, and she runs a nonprofit, and she's a social worker. She's actively employed. So a very sympathetic sort of defendant, not exactly like a Rahimi character, where most people agree on principle, people like that shouldn't have guns. It's kind of the opposite.
Rahimi had a lot of domestic violence accusations, and he was involved in a string of crimes, including shootings and car crashes, drug deals, all sorts of wild stuff that he was at least accused of. He hadn't been convicted of all those things yet, which was obviously an open question in that case that the court was satisfied with the restraining order process, but or at least they didn't fully rule on that. It wasn't really the decision, the question they were answering wasn't really about due process in that case. But regardless, these two cases is sort of almost like about the criminalization of poverty to a certain extent. I mean, yes, these people committed a fraud, either check fraud or food stamp fraud, but like the amount of money involved is so little that it's pretty shocking the consequences they faced. Now, to be fair, they didn't go to prison. Neither one of them actually went to, which is another kind of odd wrinkle in our federal laws. Like, you don't have to actually go to prison for a year to be a convicted felon who is prohibited from owning guns. You just have to be sentenced to a crime that could put you in prison for that. It's a similar thing with the president himself. President Trump, convicted felon, that's still on his record, even though the sentence was not. He ended up getting a no sentence essentially because he won the presidency, and it's I think the court determined it was impossible to actually follow through on some sort of sentence for the president while he's serving as president. And so, but it's still on the books and still prohibited person technically. Obviously there's more complication involved when it's the president and he controls the DOJ. They even before Trump, they had a longstanding policy of not prosecuting sitting presidents that they serve under. But regardless, this goes back to the idea of like you can be convicted of something, never see a day in jail, and you still lose your gun rights for the rest of your life. So that happened in all three of those instances. And there's really no practical process at this point for getting those rights back because Congress has not funded the process that exists. So basically, you're just kind of stuck this way. And so it is interesting, to see those two plaintiffs have really very similar stories, right? They made during desperate situations in their lives, they, lied to get food, basically. And that made them convicted felons and prohibited them from owning guns ever again. And so, but you see these two courts come down on opposite sides of their claims.
Yeah. So we'll have to see what happens. Obviously, kind of not only the DOJ, but gun rights advocates, pretty much all sides want the Supreme Court to address this question sooner or later. And we'll have to stay on top of whether or not the court decides. Well,
at least Biden's DOJ did. We'll see what Trump's DOJ, what they decide with all this, because that's part of the executive order, which we'll probably get into a little bit later. And we'll be covering in the full interview podcast with David Kopel, who actually you work with David Kopel at your other job. But he's Second Amendment scholar, and we'll talk to him about some of the stuff that's in that Trump executive order. But one of the things is reviewing all of the federal government's positions on these various gun rights cases to determine if they want to take a different path. So that's something we'll talk about in depth with him.
Yeah, that is an interesting wrinkle to these cases for sure. Getting into another ruling this week, this is one that you covered out of Hawaii, where a federal judge out there denied a gun rights challenger's request for a preliminary injunction against Hawaii's ban on selling guns to adults under the age of 21, essentially. It's another one of these under 21 gun regulations that have been sort of a hot topic in Second Amendment litigation lately. Yep. And in this case, the judge said that the plaintiffs were not likely to succeed on their claims, and therefore the law will stay in effect.
Yeah, it's an interesting case because one, this is it's actually a Trump appointee who made this ruling, but she kind of there's sort of an interplay here between the Bruin standard that requires the government to show that its law is constitutional, and then the standard for a preliminary injunction, where there's more emphasis on the plaintiffs to show that they need this injunction to go into effect immediately, especially in the context of a law that's been on the books for decades, as is the case here. And so she leaned towards and much of her ruling is about that second emphasis on the plaintiffs having to show that they're right in their claims and that they're likely to succeed on the merits. And that's where it was actually this, I will say, reading through the opinion on this one was more interesting than a lot of these tend to be, because, after a while in the federal courts, you kind of get to a point where there's established reasonings for upholding or striking down a law, and you see them kind of repeated over and over again. Right. I mean, you've seen this obviously in your reporting as well. And so this one felt a little different than what you might expect from a judge who's going to uphold a gun restriction like this. It did have some similarities, right? One, it relied on the idea that basically youth gun violence is not a problem that was as prevalent at the founding era. That was part of her claim, to use that Bruin standard to sort of that lets you take a more loose approach to historical analogs that are required to uphold modern laws. So that was part of this. But the judge in this case, Judge Ataki, she seemed to really struggle with the idea. Some areas of Second Amendment jurisprudence that are still not settled at this point. At least the Supreme Court has not weighed in on them fully. And in fact, you've seen Justice Amy Coney Barrett raise this question during some of the Second Amendment cases that she's sat in on. And the specific question here is, what period of time do you look at for binding historical analogs? Because she goes through and she says essentially the founding era, there aren't really good, strong analogs for what Hawaii has. Hawaii essentially has, there was also some question about exactly what Hawaii's law does, but she said both the plaintiffs and the defendants, the state, treated it as a ban on possession for 18 to 20-year-olds of any guns. So, that's pretty far down the spectrum as far as these age restrictions go. But she noted that there was nothing like that during the founding era, and she gave some credence to what we've often seen in these cases, which is the Militia Act of, I think, 1792, if I'm remembering the date right, where people, men of military age, which they set at 18, would be required to report with a firearm themselves, meaning that obviously they'd have to bring their own gun. Now it could be their parent's gun or something like that, but the plaintiffs here, and in a lot of these cases, say that implies that the founders understood 18 to 21-year-olds to have Second Amendment rights, that they were able to own guns if they had to report to marshaling or mustering for militia service. And she acknowledged that, but said it didn't necessarily agree that it went quite that far. And she pointed to the upper range age limit for militia service being like 45, and said it wouldn't make sense to say that people over 45 don't have gun rights. She went through these things. She said the founding era, there isn't really a strong analog for Hawaii's law. But then the question is, what about the period around the ratification of 14th Amendment, the mid to late 19th century, where you're using the 14th Amendment to incorporate the Second Amendment to the states? That's how the court has done this for basically the whole Bill of Rights. They're saying the 14th Amendment guarantees these rights against state laws as well, not just federal laws. And so if that's the case, well, should we look at the history and tradition surrounding the 14th Amendment? Because that's when, as far as the court is saying, the Second Amendment right was incorporated against state restrictions. And in that time period, she said there were a lot more historical analogs that were closer to Hawaii's ban. Not necessarily a direct match or a dead ringer, but closer. Bans on carry for people under 21. Some states banned. These are mostly southern states right in the lead up to the Civil War, or in the immediate aftermath of the Civil War, sort of Reconstruction era. Most of them fall into, but they ban handgun carry, but for people under 21. Some of them ban handgun possession for people under 21. Some of them, I think there was maybe one law she found that was more of a direct ban on all possession for people under 21. So, or at least, they mostly focused on handguns at that time period, which she recognized this is not a perfect match, but it is very close, and it is for the same reasons. And it's after, in her mind at least, after sort of a technological advancement in guns that made youth gun crime more of a societal issue than it had been during the founding. So, it is, I think, among the more interesting arguments that I've seen from a judge who's upholding this. A lot of them will just sort of rely on Supreme Court dicta, or they'll say, the same concept of new technology creating new societal issues, and then they'll just kind of throw any example of restrictions at the wall. This is a much closer case to where, you have real analogs, but the question is whether they're from the right time period and how close exactly they need to be for the modern law to withstand scrutiny. And she honestly doesn't even answer that question necessarily. She just says, at this point of the proceedings, where we're talking about a preliminary injunction, the plaintiffs haven't, I'm not convinced enough that they're going to win. They might win on the merits. And that's the first time, usually in these cases, and I'm sure, frankly, it'll probably still be true for this case, but usually in these cases, when you lose the TRO and the preliminary injunction, you're not going to win on the merits. The judge isn't going to come around to that. And that probably wouldn't happen here either, unless you found some new evidence to support your position. But this one felt more like she actually might come around down the line if there were, on a fuller briefing, perhaps. But anyway, that's what struck me about the case, the ruling. It was a bit more what you want to see from a judge, even if you don't agree with the outcome that they reached. So interesting.
It is interesting, and it's one of the few times that we've seen judges sort of uphold youth-based restrictions, because that's one of the ones that have been more consistently going gun rights advocates' way since Bruin.
Even before Bruin.
Yeah. And even before Bruin, you started to see that trend a little bit as well. And it's, once again, we're going to sound like a broken record here, but this is another one that's sort of crying out for Supreme Court review, especially after a couple of weeks ago, the Fifth Circuit, struck down the federal handgun sales ban to under 21s. And that still is, a merits ruling that kind of invalidates a portion of federal law. So once again, we'll have to see what the Trump administration does and what the Supreme Court does on this question.
Right. Because this widens that split, or at least has the potential to. This is a district court instead of a panel or en banc ruling, but it's still, trending in that direction. Certainly it's the Ninth Circuit, right? So you'd be surprised if a panel went the other direction, but you never know.
I think that's a safe bet. But heading into state courts, we actually had a state court ruling this week in sort of the ongoing, long-standing saga in gun rights advocates trying to take aim at Illinois' FOID requirements, the firearms owner's ID card requirements. Basically, Illinois requires you to get a permit to both purchase and possess any firearm. And this case actually arose from criminal proceedings where a woman was in a dispute with her estranged husband, and he claimed that she fired a gun in the home. And police, obviously responded to the scene. They recovered I think it was a bolt action 22 caliber rifle next to her bed. They found no evidence that she had ever fired it. That those claims, they didn't find any evidence that allegation was true, but the fact that she had that rifle and did not have a FOID card meant that she was charged with a crime. And this has been going on for 8 years, and it's gone up and down the Illinois state court system. And so this is the third time. Right? Yeah, this is the third time that the trial court has struck down Illinois' FOID requirement. First time it was as applied to this woman, and now the judge is saying, like, I can't construe any situation in which FOID is constitutional, at least for owning firearms in the home. So we'll have to see what happens here.
It is interesting because, I don't know, obviously this judge was relying a lot on Bruin and Heller in particular. So these federal precedents do still have weight in state courts oftentimes, right. Especially because of incorporations. We just talked about the Second Amendment applies to states, not just the federal government, as applied through the 14th Amendment, incorporated through the 14th Amendment. But this one I'm be fascinated to see what happens with this, because I would say before Bruin, you had a better case that these permit to purchase laws are unconstitutional, honestly, because in Heller, they put a lot of emphasis on the idea that, DC's handgun ban applied inside your home and to just mere possession in the home. And they were kind of putting that at the core of the Second Amendment, right? That at the very least, if it protects anything, it protects this. And so they seem to be making a distinction between possession in the home and like carry outside the home, or something like that. However, when you get to Bruin, and so you can make these arguments before Bruin that permit to purchase laws, maybe a permit to carry a gun might be acceptable because carry is not part of that core right that the Second Amendment protects under Heller. And so, maybe the permit laws for carry are okay, but permit laws for possession are another question, should have to meet a higher standard for constitutional review. But after Bruin, Bruin essentially set carry and possession in the home on the same level. Right. Which obviously, for your gun rights advocate, that sounds like a good thing. And it is. Right. Except that in Bruin, it was quite clear and there's a concurrence from Roberts and Kavanaugh, I believe it was, that says essentially, this form of permitting that the New York state government had engaged in, which was, May issue, which was very subjective. It allowed officials to just deny people permits if they felt they shouldn't have them, not based on any sort of objective criteria. That kind of permitting is not allowed for gun carry because the right to bear arms is right there alongside the right to keep arms in the Second Amendment, and they're on the same playing field. However, they made it clear that they believe that some kind of permitting, shall issue permitting, for instance, where you take away that subjective nature, is probably fine, is constitutional, but doesn't violate the Second Amendment. And so if carry and possession in the home are on the same playing field, and it's okay to have shall issue permitting for carry, the implication there is that it's okay to have it for possession inside the home, these permit to purchase laws. So that's obviously, this has not been resolved by the court by any means, and they may take this view that this state judge in Illinois takes on the matter. Maybe they will go back to sort of favoring possession inside the home a little bit more over carrying in public. But as things stand now, that's the only thing that makes me wonder about this, like where this ends up eventually. Because his ruling is certainly sound if you look at Heller and the way they talk about possession in the home. But if you look at Bruin and the way they say, essentially carry is on the same level, but also you can require permitting for carry, at least certain kinds of permitting. And the FOID card is on the shall issue end of things. It's certainly a bit more cumbersome process, perhaps, than like a Pennsylvania concealed carry license is, but it is on the shall issue end. It's not a may issue permit. They can't just deny you because they don't think you have a good reason to buy a gun. But yeah, so it'll be interesting to see how this plays out, or if the Supreme Court ever weighs in on this, because I think the implication from Bruin is that, if permitting is okay, at least shall issue permitting is okay for gun carry, and gun carry is subject to the same protections as gun possession in the home, the implication is that gun permitting for possession in the home is also acceptable. But I don't know, maybe the court will find some way to reconcile those things differently than what appears to be the implication. But yeah, that's what I thought of when I read this.
Well, and it'll just be interesting to see if the Illinois State Supreme Court even touches the constitutional issues at hand, because the previous two times this has gone up to the Illinois Supreme Court, two previous times, and both times the state Supreme Court punted on procedural grounds and didn't even address the constitutional claims. And so now gun rights advocates, I quoted a few that responded to the ruling in the piece. They're finally saying, we don't see how they could duck the claims this time, but we'll have to watch. And so it kind of makes you wonder if it'll even get addressed this go around, because it hasn't the two previous times. But
yeah, and I'll be real interested to see what the Illinois Supreme Court says about all this as well. Yeah. If they're going to take that same track that I just mentioned, or if they have some other view of things, we'll probably find out, or maybe we won't, I guess, is your point you just made.
Yeah. We'll keep you updated either way. As you mentioned at the top of the show, one other thing we wanted to touch on that happened last week, but we didn't get to it in last week's news update, is that President Trump finally addressed gun policy and gun owners' desires from his new administration by ordering essentially his administration to just do a blanket review on things that may or may not impact the Second Amendment. So kind of a vague, broad, and potentially ambiguous mandate for his administration. As you mentioned, we'll have Dave Kopel on the show to kind of get into the nitty gritty, but that's obviously noteworthy that he addressed gun policy in a concrete way finally. Yeah.
Well, not concrete yet, I guess, but has a lot of potential to become concrete in the short term here. And it is finally, because he's moving so fast on a lot of these other things that they're doing. And he did promise to do this stuff within the first week, and instead it took the third week, which, I don't know how much that's going to upset gun rights activists.
Right.
If they end up doing it in the end, I don't think people are going to be too terribly put off by the fact that it didn't happen literally the first week, even though, it does speak to the priorities of the administration. But just because you're not the top priority doesn't mean he won't, this administration won't do what it said it would. But it hasn't actually done it yet. I guess is one of the points. Like, they just, as you said, it's more of a review. It's a bit of an odd thing, and we'll get into this with more with Kopel, because they listed out basically all of the areas that gun rights activists want the executive branch at least to look at. Things like rolling back Biden's rules, which is what Trump had specifically promised to do. Although he didn't specifically say exactly which rules he wanted to roll, he just said all of them. And so we'll see if they go down that path, or if they don't decide not to try and roll back some of these things. Because that's another thing. This goes to Bondi, who obviously we've talked about has received criticism from gun rights activists for her mixed record on the issue, supporting things like red flag laws and age restrictions when she was Attorney General in Florida. So she'll have at least some say in this process, and it'll be interesting to see what exactly she comes back with as far as things that infringe on American Second Amendment rights here. But, it kind of sets up a scenario where they've identified all the things that gun rights activists want them to do. That's what they're reviewing. It's only a 30-day review, so it doesn't feel like they're legitimately going to actually have some sort of thorough review process. It just feels like they're going to decide, a little bit of a delay to decide exactly which one of these already pre-known issues they're going to try and tackle, which implies to me that they're not going to do all of them. Although I would imagine they're going to do some or most of them, because it would be pretty wild for them to put out a list of the top priorities of the gun rights movement and then not do any of them. Right? I don't foresee that happening. That would be pretty bizarre thing to do. But yeah, I would also imagine if you were going to do all these things, you'd just do them instead of this 30-day review period thing. But we'll see what happens. I can't predict the future, certainly. And we'll get into exactly the minutia of what, there's sort of seven areas that they're looking at. And I think Copa will be a good person to come in and explain what specific actions could come out of those areas. So yeah, look for that interview coming up. It'll be out on Sunday for members and Monday for everybody else. So I think we'll have probably the best policy analysis of this executive order coming here on the show real soon.
Yeah, listeners should check that out. Touching on a few newsletter links before we wrap up here today. One of them comes to us from The Hill, from David Yamani, actually, who's written for us in the past and been on the Reload podcast. He writes about, essentially, he makes the case, an analysis type about a new generation of gun owners, sort of along the lines of his sort of gun culture 2.0 thesis. And essentially the thesis of the piece is gun owners are not just white conservative men. And this is something we've covered, obviously a major storyline in sort of gun culture going forward. And he lays out a pretty good argument in this Hill piece.
Yeah, it's a really interesting piece. We'll have to have him back on the show pretty soon, I think. He's always got good insight, but obviously that's his area of study, is this concept of gun culture 2.0, this shift of gun ownership towards a more diverse, more urban and suburban, more minorities, more women, more interest in self-defense and sport, like tactical sport shooting over hunting, shifting into a more diverse community of people who want to own firearms. And he said, he claims in that piece that this is accelerated somewhat by the election of Donald Trump. And we have seen some anecdotal stories to that effect. I think gun sales have been pretty depressed here lately. I think they were up slightly, according to the National Shooting Sports Foundation, year over year in January. So, there's been more or less, I think it's been more or less flat for the last several months. So, you're certainly not seeing a massive uptick in gun buying because Donald Trump won the election at this point. But there have been, perhaps on a smaller scale, we've seen stories of people who were, made the plunge to buy guns after his election. But obviously Yamani is focused more on the broader trend there than, perhaps whatever's going on in the wake of the last election. And, I think on that end, there's a lot more hard data that you can point to that shows there has been a shift. And it's really a shift that's been going on for quite a while, not even just since the pandemic, although that accelerated things. So definitely a piece worth reading.
Yeah, Yamani stuff's always interesting. Good stuff. Next one we're going to talk about just briefly. It's a new entry into this sort of trend we're starting to see. This comes to us from the Associated Press, reporting on the fact that Baltimore and Maryland have now joined the bandwagon of suing Glock, one of the biggest, obviously, gun manufacturers in the country.
Yes.
Alleging that their handguns are too easy to illegally convert into machine guns, and then that's Glock's fault. So now that adds on to suits that already existed in places like Chicago, New Jersey, and I think Minnesota were the three. And so you're starting to see that this is a trend that at least these cities partnering with gun control organizations like Everytown think that this is their new chance to get some gun maker liability going.
Yeah, it kind of reminds me, obviously it's similar to these suits that gun control activists have been filing since the 90s, trying to hold gun makers accountable for the criminal acts of third parties, which has been a huge political fight over the decades that led to obviously a federal law called the Protection of Lawful Commerce in Arms Act. And, constant attempts to sort of circumvent those protections by gun control activists who argue that gun makers are at least partly responsible for gun violence. But this actually reminds me a bit more of I think Chicago sued like Hyundai, Hyundai and Kia because they claim their cars were too easy to steal. Like it's just kind of an odd claim, given that you're like blaming the companies for the criminal doing something that they aren't allowed to. It's not like Glock designed their gun to be able to be to have the sear circumvented with the Glock switch or whatever. They didn't make the Glock switch, right? Somebody else created that thing, and it's just like, I don't know. I will see if these get any traction anywhere. I'd be very surprised if this makes it very far, these sort of claims.
Yeah, that's the key point. We haven't seen any rulings yet where a judge has said, oh, this is okay to go to trial or whatever. We haven't gotten that far just yet. And I think that'll be the tell.
Oftentimes, these cases aren't really designed to win. They're just designed to kind of tie up the companies in court and make them pay legal fees and maybe hope to get some internal documents out of them that would be publicly embarrassing. That sort of thing seems to be the end goal of a lot of these kind of lawsuits, rather than actually winning. So I don't know. We'll see what happens. Similar in some ways to Mexico's suit against Smith & Wesson and other gun makers. That's at the Supreme Court right now, which I would be very surprised if the Supreme Court sided with Mexico in that case. But again, we will have to wait and see what exactly happens.
Absolutely. But it certainly is becoming a trend. So it's worth noting. And the last one, it seems like every week now I have a new update from my home state of Colorado. Another legislative update because, it's one of the states where gun bills really do move year to year. This one's a little interesting because lawmakers are advancing a bill to essentially create a voluntary do not sell me guns registry where a person can tell an FFL or enter themselves into the CBI, which is Colorado Bureau of Investigation. We have a state-run version of NICS. For 30 days, essentially, they'll be completely banned from purchasing guns, and they voluntarily put themselves on this list. And you've seen a couple of states do this. I think your state of Virginia has something similar to this, and I think maybe Utah, but not many states do this. And so it's sort of an interesting approach. I don't know how efficacious it'll be at combating suicide, but it's interesting.
Yeah, and I can't recall what the counter argument is to something like this. I don't believe that gun rights activists are in favor of this from what I recall.
They're fighting it here. I know they're fighting it here.
Do you know what the argument is?
They're just calling it a self-red flag law. And they're saying it's not, they're more arguing against the efficacy of doing something like this. Like if you don't want to buy a gun, don't buy a gun. Why do you have to put yourself on a registry kind of a thing is sort of the,
it's definitely, this is definitely one of those new wrinkles in the gun policy space that hasn't been around for very long. And I don't know that there's even very well developed opinions on this either way for a lot of people.
Right.
And it certainly doesn't, obviously it's somebody voluntarily doing this. I guess there'd be questions about how you could get off the list later if you decide that if you are no longer in a position where you feel like you need to prevent yourself from buying guns. That would be a good question to ask. How do you get off this list that you put yourself on?
I think Colorado's version, it's supposed to automatically expire after that 30 days. So you don't have to do anything. You're supposed to automatically be removed. But you could obviously see that potentially, at one point thought you were too dangerous to own a gun. Why should we not? Yeah. So we'll have to see. But I think it's also indicative maybe of a state that's run out of low-hanging fruit for gun policies and is looking for new ways to pass gun, novel, more novel stuff. And I think that also is, a little symptomatic of what's going on here in Colorado.
Probably. Yeah, that's a good point.
We'll have to see.
Yeah. We'll see what happens with it. And it might be worth looking into these a little more just to see what the debate is and how, if there's, more momentum for these laws around the country outside of the couple states that have passed them so far. It certainly could be. I mean, it avoids some of the common pitfalls of gun legislation, which is like forcing people to not own guns, right? This is a voluntary thing. So I don't know. Certainly a unique proposal. Well, relatively unique. Obviously, it's been done once or twice before, but oh my gosh. Usually this happens at the beginning, right?
At least it waited until the end.
Show. So, but yeah, no, I think that's all the news we have for you. Although I don't, if you heard, did you see what happened this weekend? I think there was some pretty big news.
Yeah, I watched. I was giddy watching
on Sunday.
Yeah.
There's a big event that they had on Sunday. Watched all over the world. I don't know if you caught it. It's called the Super Bowl. It was between, I think there were two teams called. One was the Chiefs, and the other was the Eagles. And one was completely dominant over the other. I can't recall exactly which one was which. No, I think that was amazing. A lot of fun. We're recording this episode, in case people didn't notice, on Thursday instead of Friday this week because, there's another event happening on Friday that's kind of a big deal. Should be probably 1 million plus people will be there in the city of Philadelphia, where I was to watch the game, by the way. Watch the game. We won basically 40-6. I know they scored. It was technically 40-22, but that was well after the game was over. And then we went out on the Broad Street and partied, and it was amazing. My gosh, what a feeling. It's really a travesty that I have to go back to work at all instead of just watching highlights the rest of my life of this game. But totally dominant performance. Love the defense. Jalen Hurts MVP. Nick Sirianni, Super Bowl winning coach, 2 Super Bowls in 3 years, playoffs every year. He's got the highest winning percentage, or the second highest in the active coaches. I don't know, pretty good stuff. And then, I'm going to be there for the parade. That should be fun too. So, boy, I don't know, feeling pretty great. Things going real well in the personal life of late. Got engaged. We went to the Philippines, met my fiance's family, who were amazing. The country was beautiful. White sand beaches, amazing time. Came back. Eagles win the Super Bowl. Can't ask for a whole lot more than that at this point. But yeah, boy, pretty happy about it. Anyway, I won't gloat too much more on this today, on this particular episode. I'll probably gloat a lot more down, going on from here. But yes, that's all we've got for you guys this week. Look out for that David Kopel interview where we dive more into Trump's EO on guns. And let me throw it over to myself to tell you a little bit about the Dispatch, who we have an ad swap with this week. All right, folks, it's time to talk a little bit about the Dispatch, doing an ad swap here between the Reload and the Dispatch. And I think that's fitting because if you like what you're getting from the Reload in terms of high quality reporting that focuses on hard news, you'll probably like the Dispatch as well, because get this, they also focus on high quality reporting and hard news. Now, they are a much broader publication than the Reload. We obviously focus on one specific area, whereas the Dispatch has a much larger team and is able to focus on a whole number of other issues, but still primarily in that national politics realm like we do here at the Reload. But they are one of my favorite publications. I am a paying member to the Dispatch. And so clearly, I highly recommend it. I've been a paying member since they were founded, and I've never had reason to rethink that even once. So they are constantly breaking news stories. They are sending you newsletters on whatever frequency you want. They have quite a variety of them over there. But I subscribe, for instance, to the Morning Dispatch, and I get, I think, a very nice summary of what's really going on from a pretty sober perspective. That newsletter is hard news, and it's focused on it. And I think it's fantastic. But they also, of course, have some of the best commentators, in my personal opinion, over there as well. You know, it was an outlet founded by Steve Hayes and Jonah Goldberg, two guys I've known for a long time. They've been on the Reloads podcast. Kevin Williamson as well has been on our podcast. So you've heard from these guys if you've been a Reload listener for a while here. And, you know, I think you should check out the Dispatch if you haven't already. We have a free trial as well, 30-day free trial for Reload listeners if you want to go over and check out their paid offering, which I think is well worth the money. So I'd encourage you to do that. There's a link in the description of this podcast or on our website if you want to check it out. So head over to the Reload or to get that link, or head over to the Dispatch to see what they're all about.